that under paragraph 15 of the symbols order, when there is a split in the political party, it starts with that proposition that two factions have arisen pursuant to a split in the political party. Then which faction should get the symbol?
Will that arise in this case?
I'm sorry?
Will that arise here?
Yes, that's a question. That's a question. What is the role of the Election Commission in matters under the... That's part of the reference.
So under paragraph 15 of the symbols order, when two factions emerge in pursuance of a split.
Yes.
So what is the sequitur? How would you end the sentence?
Well, then what is the role of the Election Commission in deciding that matter? Should it await the decision of the Constitutional Court? Should it go ahead? Your Lordships only, Malaj, as your Lordships will remember, in September said no stay. But your Lordship did not say how he is going to decide it.
But that, Mr. Sibal, is your independent challenge to the order of the Election Commission.
That's a separate issue, Malaj.
We can't really decide.
No, that's part of the reference, Malaj. I'm going to argue, Malaj.
Can we, how do we...
He's saying...
Constitutionally, the Election Commission cannot proceed. Malaj, the split would have to happen on 21st of June. There was no whisper of a split on 21st of June.
Your contention that therefore the Election Commission itself cannot proceed until
Yes.
the Speaker has decided.
Correct. That's what your Lordship said. No stay, fine, Malaj, no stay. We went before the Election Commission and said, you cannot decide this matter. The matter is pending in Supreme Court. He said, no, but Supreme Court said no stay. And you will find that tomorrow, Malaj, when your Lordship sit at 3:30. But be that as it may, that's the last question that your Lordships, your Ladyship will have to look at. So these broadly, Malaj, are the issues that you might be asked upon to decide, Malaj, that you might wish to decide. Now, Malaj, let's go to the list of dates, because unless you have the facts, Malaj, it will be... Malaj, this is now PDF page 108 of the written submissions. It is marked as capital A, and I have learnt how to use the iPad.
Mr. Sibal, just wondering if you could just look at the issues that were framed.
Ladyship, I can't hear you.
Look at the issues that were framed once so that we know the perspective in which you're arguing. The issues that were framed for reference to the Constitution.
I can read those.
Can we just to review?
Yeah, I think it's a good idea.
Call before we
Reference
proceed
order.
further.
Yes, reference order. Your Lordships will have that. Order compilation, Malaj. PDF page 28.
Order compilation.
Orders compilation, PDF page 28. May I, Malaj? A, whether notice for removal of a speaker restricts him from continuing with disqualification proceedings under the 10th schedule of the Constitution as held by this court in Nabia. Well, I've already argued that. So Lordships have deferred your Lordship's judgment on that. So we'll skip that for the moment. B, whether a petition under Article 226 or 32 lies inviting a decision on a disqualification petition by the High Court or the Supreme Court, as the case may be. That's the question that I have already formulated in different, the language is somewhat different, but the intent is the same. Then C, can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision to the Speaker? Actually, B and C are together, Malaj. They are interlinked.
Per se cases.
Yes. The language is somewhat, Malaj. D, Malaj, what is the status of proceedings in the House during the pendency of disqualification petitions against the members? Malaj, it really doesn't clarify what it means. What is the status of proceedings? What it means is that can members against whom there is a disqualification petition pending have a role to play in the House while it is pending? Otherwise, you can topple any government you want. Then E, Malaj, if the decision of a speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Now, this question only arises if you allow proceedings to go on. If you don't decide on the disqualification before, then this question arises, because if at a later point in time, you consider them to be disqualified relating back to the date when their act led to a voluntary giving up membership of the party or violation of the whip, then what happens to the intervening proceedings? A government has been formed, actions have been taken, policy decisions have been made. Would it not be better, for the purposes of, I personally believe, democratic traditions, that you should await your hands till the disqualification is decided first, because this problem will not arise then. Then, F, I think, is very, very important. What is the impact of the removal of paragraph 3 in the 10th schedule? According to me, that's central to the entire issue. Because now you don't have a split. The issue of a split doesn't arise. Which is why, if you want to go to the election commission, there has to be a split in the party, not a split in the legislature. That is not on record. No such split. So this is central, and we'll interpret paragraph 4 also in that context. Then G, what is the scope of the power of the speaker to determine the whip and the leader of the House legislative power? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, it's actually, again, convoluted in its expression. In simple terms, it means that how is a whip appointed and how is a leader in the House appointed? Is there a role of a political party, or is it something that the legislative party decides? Can majority of the legislative party members decide, I'll change the whip tomorrow? Can't be. So what has happened in this case, and I'll come to the facts, that sitting outside the House, X number of people said, you are no longer the whip. And those are members of the legislature only. I can give your lordship's documents to the effect. What happens is, when a leader of the House is appointed, the letter that is given to the speaker is that the party hereby decides that this person will lead the House for the party. It's not the members of the legislature don't decide these issues. Similarly, whip. Because the whip is the bridge between the government, or the opposition, whichever party it is, and the House, members of the legislature. That's why your lordships will see that nowhere in the Constitution does the word political party is referred to, except in the 10th schedule. Because in the Constitution, you're dealing with institutions. You're dealing with an institutional framework within which all political parties function. In the 10th schedule, you're dealing with framework within which a legislative party functions in the context of the political party, resulting in disqualification. Then, H. Are intra-party decisions amenable to judicial review? I don't think that question arises. There is no intra-party decision in the legislature. So your ladyship is right that we need to look at some of these questions. Then I, what is the extent of discretion and power of the governor to invite a person to form the government, and whether the same is amenable to judicial review? Well, it's a governor's actions are always amenable to judicial review. That's not an issue at all. Question is, what should a governor do in the context of disqualification petitions pending and which are yet to be adjudicated upon? As a governor, who represents he is a constitutional authority, he needs to protect the Constitution and the laws. In this very state, a governor, Malads, in the early hours of the morning, gave an oath, to the oath of office, Malads, made somebody a chief minister, and by the early morning, Malads, on daylight, he had to resign. Governors, and I say this with respect to all the institution of the governor, that governors have, in my respectful submission, acted far beyond their constitutional responsibilities, as we have seen, as I have seen in the recent past. That may not be a proposition that the other side will accept, but I'm giving only my view of the matter. It is unfortunate that governments are actively involved in the politics of the country. Then, Malads, the last one. What is the scope and the powers of the Election Commission of India with respect to determination of a split within a party? That's where, Malads, the question of para 15 of the symbols order comes in. Let's kindly now come to the written submissions of the petitioner. And the list of dates is at page 108. PDF 108.
Submission.
That is A, right? A, petitioner written submission.
One's in, yes, A. PDF 108.
Return submissions, no?
Yes,
You are referring to return?
yes.
Not additional return submissions. Not additional return submissions.
A, Malads, A.
Okay.
A.
Page 108, PDF.
Mr. Sibal, what we could also do is that, of course, we've seen the broad points of reference, but ultimately we'll need to narrow down the reference to the issues which you want to focus on.
Yes.
And maybe if you could, during the course of the afternoon, share that with the other side. We can have their feedback so that we narrow it down to certain specific issues